In May 2026, a trial concluded at the Gauteng High Court in Pretoria that is being closely monitored by professional services firms across South Africa. 4 of the country's largest law firms have mounted a highly coordinated legal assault against the government's new B-BBEE Legal Sector Code. For these corporate megafirms, the threat is financial and immediate. If they lose, strict new compliance rules could trigger rating downgrades that jeopardize the 15 to 20% of their revenue derived from public sector contracts. For the state, a loss would invalidate years of sector-specific economic policy, resetting the timeline for demographic transformation in the legal industry. This trial has moved beyond a standard regulatory dispute into a conflict over the specific ownership and revenue percentages that will define the sector's elite. The specifics of that conflict were formalized in September 2024, when the Department of Trade, Industry, and Competition gazetted the Legal Sector Code. The government cut the revenue threshold for large firms in half, to 25 million rand, subjecting mid-size firms to stricter compliance. It targets 50% Black ownership, with half held by Black women. Falling below sub-minimum targets triggers an automatic one-level B-BBEE downgrade. The law firms argue that the speed and strictness of these targets make them impossible to achieve without damaging their existing business structures, leading them to challenge the legal foundation of the code itself. The applicant's first argument is procedural. The state failed to issue a legally required guiding strategy before drafting and gazetting the code. But the structural argument is more significant. The firms claim the government's framework overlooks how practitioners actually operate, specifically regarding how cases are won and how fees are split between advocates and partners. Practices with 1 to 3 partners account for 95% of the South African legal industry. Falling below the 25 million rand threshold, they are entirely exempt. Counsel argued a code targeting only the top 5% cannot credibly transform the sector, making it legally irrational. The firms conclude that the framework is so flawed at its foundation that the court cannot amend it. Instead, they are seeking a ruling to strike it down completely. The state's defense is supported by a unified front, including the General Counsel of the Bar and the Black Conveyancers Association. They argue that focusing on revenue thresholds ignores the systemic exclusion of Black professionals from the most influential parts of the legal economy. Regarding the 5% paradox, the defense points out that this small group of corporate firms controls the majority of market power and elite case experience in South Africa. The leadership at these top firms creates the professional pipeline that eventually determines who is appointed to the national judiciary. For the defense, the demographic composition of these firms is not just a matter of compliance, but a direct factor in the future credibility and representativity of the justice system itself. Judge Nicoline Jansef van Nieuwenhuizen has reserved judgment, with a final ruling expected by late June 2026. If the court strikes the code down, the legal profession reverts to the generic B-BBEE codes. This would reset transformation timelines and force the state to restart the entire rulemaking process from the beginning. This chart shows the alternative. If the code is upheld, large firms face immediate rating downgrades. This abruptly halts the flow of public sector revenue that these firms use to fund their own internal training and transformation programs. With the June deadline approaching, legal and procurement teams are preparing for 2 vastly different regulatory environments without knowing which one will become law. The implications of this case extend beyond the legal profession. Other professional services, including accounting and engineering, are currently in negotiations over their own sector-specific roles and are watching this trial for a definitive legal precedent. A ruling will either validate the government's sector-specific transformation strategy or provide a legal blueprint for other industries to challenge aggressive quotas. The final judgment will determine how economic transformation policy is drafted and enforced across all of South Africa's professional